How do you know the defense is serious about trying to negotiate and resolve your case? Would you like to know the answer? Come join me for a walk around the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. You know that the defense is serious when they come right out and they make your attorney an offer. And it's a substantial offer. Or you get a call one day from your attorney to tell you that the defense has reached out to them and they are interested in trying to mediate your case. That's another indication that they are serious about trying to resolve your matter. Now, if during the course of settlement discussions you make a demand of, let's say, $5 million, and the defense comes back with an offer of $10,000, what does that tell you? It tells you that they are not serious about trying to negotiate your case, no matter what they said before. An offer of $10,000 is not just insulting, but it's absolutely outrageous in light of a demand of, let's say, $5 million. If they wanted to get serious, they would make a seven-figure offer. They might offer $2 million. And now they're getting closer to the ballpark, but an offer of only $10,000 doesn't even put them in the same universe with what you believe your injuries are really worth. Before your attorney can actually have an intelligent conversation with the defense, he has to have a real discussion with you to go through all the risks and benefits, all the pros and the cons about proceeding forward or resolving your case at an early stage. It is critically important that you have a clear understanding about the risks of accepting a guaranteed offer, about the risks of rejecting a guaranteed offer, and about the risks of going to trial. Because you need to know every single risk that's involved with turning away a substantial settlement offer, even though it may not be the ideal amount that you originally asked or are hoping to get. You at least need to be aware of those risks so that ultimately you, as the injured patient, as the injured plaintiff, as the person who is bringing the lawsuit, has the ability to make an educated decision about whether or not to turn away a guaranteed offer. Now, what are the risks of accepting an offer? The risk is that you are going to regret your decision months or even years down the road. That is a risk. You may turn around a year later and say, you know what? I should have held out for more. I should have taken this case to trial. I should have X, Y, and Z. That is a risk. On the other hand, what is the risk of actually rejecting an offer? Well, remember, anytime an offer is made, if you accept that offer, that is a guaranteed amount of money. So now, after the attorney's expenses are reimbursed to his law firm, the attorney's fee is then calculated. Out of that remaining amount, you have to determine, or your attorney has to determine, whether there is a lien by anyone such as Medicare or Medicaid, which means that you have received certain benefits from a federal or a state agency that is required to be repaid. And oftentimes you can, or your attorney will negotiate the amount that has to be repaid depending upon the settlement amount. After that is dealt with, now the remaining balance goes to you, the injured patient. And that amount is typically tax-free. There are one or two exceptions where it's not, but for our purposes, generally we're saying this amount is tax-free. Now, are there any other risks? Yes, there are risks. Let's say you reject an offer and now you decide to go to trial. You go all the way to trial, maybe a year later, maybe 6 months later, and now you have in your mind that your injuries are worth $10, $15, $20 million. And you know what? Maybe they are. But a jury doesn't see it that way. The jury recognizes that your doctor, whom you sued, was careless, and they also recognize that his carelessness was a cause of your injury. But now it comes time to give you money as a form of compensation for all the harms and losses and damages that you suffered because of this doctor's carelessness. And they don't feel that your injuries are worth anywhere near what your attorney has suggested. So now the jury comes back with something substantially lower than what you had previously been offered during settlement discussions. Can you go back and get what was previously offered by the defense? The answer is no, you can't. That is a risk of going to trial and rejecting a substantial settlement offer. Now, I will tell you, there are some cases where an attorney will have an agreement with the defense to have what's called a high-low arrangement. So let's say they make an offer of $1 million and you believe your case is worth $10 million. And now you know that you should be receiving at least, at a minimum, $1 million. And the defense says, you know what? we are willing to negotiate with you, or at least go all the way to trial, and let a jury determine how much you are to receive, since we obviously can't agree on a number. The attorneys might negotiate a situation called a high-low arrangement, which means they may come to a certain parameter. They may say, okay, let's do this. We guarantee that you will get at least $500,000 with a maximum of $5 million. All right, let's say that's the high-low. And if a jury comes back with $2.5 million, you agree to take it. Anything between the $500,000 and the $5 million, you agree to accept, and that's the end of it. That's a high-low agreement. What happens, though, if a jury comes back and says you are entitled to receive $10 million? Well, guess what? Based upon this high-low arrangement that you and your attorney and the defense has agreed to before going to verdict, guess what? Now the maximum you can ever receive is $5 million. Let's say, on the other hand, the jury comes back and says, sorry, Mr. Patient, we don't think you should be receiving anything, or we think you should get $25,000. Because of your arrangement with this high-low agreement, the minimum amount that you are going to receive will be, in this case, $500,000. So although the jury determined that you are only to receive $25,000, because of this prior arrangement that you worked out with the defense as part of negotiation, you will receive $500,000. So there are risks associated with accepting an offer. There are risks associated with rejecting an offer. There are risks associated with going to trial and taking a verdict with 6 people of the community whom you do not know. You don't know what their biases are. You don't know anything about their backgrounds. You don't know anything about them. And you don't know how they're going to interpret your injuries. So this all has to be calculated out beforehand as you begin to negotiate. And one of the things that we talk about when we're negotiating is, okay, let's take all these risks into account. And then oftentimes I will ask my client, I said, listen, are you the type of person who likes to gamble? And oftentimes they look at me like, what are you talking about? Do I like to gamble? No, I don't like to gamble. Do you go to Las Vegas? Do you go to Atlantic City? I said, okay, let's say you do like to gamble. Are there instances where you have $1 million sitting on the table? Let's say you're playing blackjack, and you decide, you know what? In a crazy moment, you say, screw it. I'm going to put all my money, $1 million, on this next card. Have you ever done that? Are you comfortable doing that? What do you think the chances are that the card that you pull next is going to be a winner, or even blackjack? If you are comfortable doing that and letting it all ride, the $1 million, on one single card, you are now risking it all. That's the same scenario when the defense comes back with a very substantial settlement offer that is close to, if not full value, of your injuries. You may get in your mind that your injuries are worth much more, and you may turn around and say, you know what? Screw that. I'm not taking the offer. I want to go to trial. Well, that's fine, but now what you're doing is the same exact scenario I've described by going to Atlantic City, going to the casino, and putting it all on that one card, putting it all on that one roulette spin. You are now taking a guaranteed offer and now taking a chance that you will get more. Now, something else you should be aware of. If a jury does come back and give you more than what you had been offered during the course of settlement discussions, there is the significant chance that the defense is going to do a number of things to try and get your case thrown out. They're going to ask the judge to throw your case out as being against the weight of the evidence, meaning that the evidence is not consistent with such a large verdict. Then, no matter what the judge decides, in all likelihood, they're going to appeal that decision. And they're going to ask the appellate court to turn around and say, you know what? We don't think that Mr. Oginski and his client were able to sufficiently prove that his client's injuries are worth X, Y, and Z. And now we ask you to throw that verdict out. We ask you to throw his case out. There are many options that the appellate court has in evaluating whether or not the verdict is appropriate. They could throw the whole thing out. They could reduce the amount that you've been given. They could, in some limited instances, increase that amount if they felt it was insufficient. And they could also turn around and say, you know what? There was a problem with how the jury came to their conclusion. We are going to send you back for a brand new trial, and now the jury will have to assess and evaluate damages all over again. And now, what have you done? You've bought yourself a new trial and more uncertainties. So why do I share this quick information with you? I share it with you just to open your eyes, to help you understand how these types of cases work in the state of New York. You know, I recognize you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are thinking of doing so, but still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.